This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Ms. Lindsay. And on behalf of Judges Bennett and McBrayer, we welcome you, Mr. Pepper and Ms. Elliott, to this oral argument. We will conduct the hearing in the same fashion as if we were all together in the courtroom. The argument is not only being recorded, but it is also being live streamed for public viewing in our efforts to maintain open courts. I understand that the appellant has already reserved some time for rebuttal. So without further ado, I will ask Ms. Lindsay to call the case.
LVH LLC versus Freeman Investment LLC.
Thank you, Ms. Lindsay. Mr. Pepper, you have the floor.
Good morning, Your Honors. I'm Ross Pepper. I represent the appellate in this case, Freeman Investment LLC. This case, as the court, I'm sure recalls, involves an option contract for a piece of property of approximately 11 to 12 acres in Davidson County, Tennessee. We have raised three issues in this appeal. The first issue we have raised is that the trial court erred because it held that the option agreement was enforceable. It is our contention that the option agreement is unenforceable for two reasons. The first reason is that there is no definite price in the option agreement. It is simply an agreement to agree, and such agreements to agree are not enforceable contracts under Tennessee law. Secondly, it is not an enforceable contract because even if the court determines that the option agreement contains a purchase price, let's say of $2.5 million, there was never an acceptance, never an effective acceptance of that offer by LVH. In fact, I'm jumping ahead a little bit, but the trial court itself found that the response of LVH after it exercised the option was an offer and not an acceptance. The third issue we are raising in this appeal is that the trial court erred by awarding compensatory delay damages to LVH for rent that LVH claims it would have received had this option agreement gone through. Let me start with the option agreement is unenforceable because it is an agreement to agree. In Tennessee, and our Supreme Court has recently said in the healthcare specialist case that the party's written contract is the lodestar that's to be used to interpret their contract. The party's option agreement in this case, which is the final expression of their agreement, contains four references to the express references to the parties agreeing on a price in the future. In fact, after the paragraph that is titled option price, the very first sentence is to be mutually agreed upon by buyer and seller. There is no possible way to find a definite price in this contract without completely ignoring the four separate references to a price to be agreed to in the future. That is exactly what the trial court did. The trial court, there is a phrase within paragraph 2, the phrase is at a price of $20,000 per residential unit that can reasonably be developed on the property. Assuming that that is a formula by which you can arrive at a price, the trial court looked at that and said, that is an expression of, that proves the parties agreed agreed on a price in this contract. But then the trial court completely ignored and necessarily ignored all of the other references to mutually agreeing in the future. The trial court did not construe this document in a way that the trial court tried to make all these references to negotiating about a price in the future somehow harmonious with this one clause that does have a formula in it. The trial court just said, this is what we're going to do. We're going to not pay attention to the first clause, which under Tennessee law, we have a long history of contract interpretation law that says where clauses conflict, the first clause should control, not the second. The trial court did just the opposite. The trial court disregarded the language to be mutually agreed upon in the future and made the operative phrase, this phrase that says at a price of $20,000 per unit that can reasonably be developed. We submit that this case is indistinguishable in any practical sense from this court's decisions in the 4-8 in the Huber case. In both of those cases, the court said there is a way in this contract, there is essentially a formula. However, because the parties also sprinkled in an intention, an expression of intention about agreeing on a price in the future, it is a mere agreement to agree. And there is no distinction between the case before this court now and the 4-8 and the Huber cases. If the court does find that these clauses in paragraph 2 conflict, then this court could also determine and conclude that these parties, that there was never a meeting of the minds. I will say this is a terrible contract. The only good thing I can say about it is no lawyers were involved in the drafting of this contract. And it does seem like you have one party who's trying to say, I want a purchase price and here's how we're going to figure it. And the other party's saying, no, put that language back in. We want this, we want to discuss this in the future. And if that's what happened here, and I think there's that's plausible that it happened, especially without involving counsel, then what you have here is a case where there is just no meeting of the minds. And of course, in Tennessee, there's no meeting of the minds.
I find it sort of implausible, your theory, because why would the developer here go to all the expense of getting the property rezoned if they didn't have at least some handle on being able to exercise an option to acquire it? Or were they just doing that out of the goodness of their hearts?
Your Honor, I don't think they were doing it out of the goodness of their heart. I would also point out there is not one shred of evidence in the record. They keep saying they have spent a significant amount of money. There is not one shred of evidence in the record to support that. And I would also say, whatever their motive and however they may have acted, you also have a final agreement and an expression in this contract that the parties will negotiate in the future. And that may seem implausible. Again, there's no evidence in the record about how much money they spent. What they got out of this, even if they didn't have a definite price going into this, they got something they didn't have on the front end. They got the ability to go onto that property and to do due diligence for a year while Freeman could not sell that property to anyone else. And again, the fact that may have been LVH's motivation doesn't change the fact that we have a terrible contract here. That if that was their intent, they did not provide for it in the written agreement, and it is the written agreement that controls, and not what the parties subjectively intended. I would also
well, is it possible to read this option in a way that says that really there was only one way that this could be an enforceable contract, and that is in the circumstance that happened here, which is namely the Planning Commission did not approve more than 125 units. And because it did not reach that threshold, that ended up resulting in an enforceable contract, at least providing a price term.
Well, the Planning Commission approved 130 units. And what I would say to that is, had the parties intended that the number of units that reasonably could be developed depended on what Metro approved, they would have put that in the contract. I would also point out, Your Honor, that when the parties' intent in this contract, if you look at paragraph B, is the number of units would be based on a site plan under adoptive residential zoning standards. That was what they agreed to. After they execute the agreement, LVH finds out Metro will not let them apply adoptive residential standards, so they submit a site plan under a specific site plan. We don't know if they would have followed the contract, how many units they could have built under adoptive residential standards.
But isn't that what B2 means when it says upon project completion, a price of $20,000 per residential unit upon project completion? So, if more than 125 are completed, then you get 20,000 plus times that extra amount in addition?
Well, it certainly could mean that, Your Honor, except again, if you go back to the introductory sentence of this paragraph in option price, that the parties will mutually agree upon a price in the future, that changes everything. If you take that phrase out of this contract, I would agree with you that you can get to a more definite price. But the question you're posing to get to that price, or to any definite price in this case, you've got to completely ignore the first clause of that paragraph 2. You just have to totally ignore it. So
do you have to totally ignore it, or does it refer to the number of residential units that are reasonably developed on the property?
Well, it does not refer to the number of units that can be reasonably developed because it comes right after option price. However, if it refers to the number of units, that still would be negotiated. That's still a point to negotiate. The parties did not agree that whatever Metro decided under a different zoning plan than they put into the parameters would control what could reasonably be developed.
All right, thank you, Mr. Pepper. We'll hear from you again on rebuttal. In the meantime, Ms. Elliott, you have the floor.
Thank you, Your Honors. Emma Elliott of the Nashville Bar here on behalf of Appellee LVH LLC and the plaintiff before the Chancery Court. And I guess I'll start by agreeing with Mr. Pepper on one thing, that this is not a perfect contract. No lawyers were involved, as he mentioned. However, this option agreement does contain an ascertainable price term and is therefore an enforceable contract between the parties. Paragraph 2 of the option agreement sets the option price, as we've discussed, at a point of $20,000 per residential unit upon project completion that can be reasonably be developed on the property subject to the following parameters. And of course, those parameters go on to define what it means for a unit to be reasonably developed on the property, such as height and zoning restrictions, bedroom unit mixes, parking spaces, etc. It also sets a floor price based on a minimum of 125 units to be developed on the property. And of course, 125 at 20,000 per unit, we get to the 2.5 option price floor. Briefly, I'd like to point out as well that Freeman's agent, Mr. Lewis, at deposition also acknowledged that the parties were setting a floor for the price. And that's in the record, where he expresses that we have a minimum number of units, or whether it's a minimum price per unit. What the parties are doing is setting a formula to set that floor because that benefits Freeman. If, as what happened here, LVH is unable to, in fact, develop 125 units under these parameters, Freeman is guaranteed that minimum option price of $2.5 million. However, if they're able to develop more beyond 125, Freeman gets the benefit of $20,000 per each additional unit that can be developed on the property.
Well, then what does the to be mutually agreed upon at the just before that formula mean?
Your Honor, that language, which does appear in paragraph 2, could reference a number of other things that the parties could need to agree upon in the future outside of this clear formula for the purchase price. For instance, the parties refer to a joint venture agreement or partnership terms at multiple times in this contract. And in fact, in paragraph 3, in the same language where they talk about future mutual agreement. And the court properly interpreted this contract, which under Tennessee law, we look to the attendant circumstances as well of the entry of this contract. And this contract was entered by the parties at a time where we've discussed development hadn't begun, where there was a sense that there would need to be rezoning, flood remediation, how many units could be developed. We didn't know any of this at this point. LVH did not.
What about in paragraph B3, option earnest money, where it talks about the money could be refunded if the buyer terminates this agreement or buyer and seller cannot agree to an option price?
I believe it continues as well in option
or partnership termination, yes.
or partnership terms.
Yeah.
And so, Your Honor, again, we kind of acknowledge that these terms are not the clearest as day. A lawyer probably wouldn't have put these in there. But again, we have this partnership language in there. There are other things that that could be decided between the parties outside of these core material terms of option price. And because Tennessee law, again, preponderates against the destruction of contracts when there is clear material terms included, as we have here by our formula, we believe that that all goes against the destruction of this contract for indefiniteness. The only thing that would need to be determined under this formula is how many units can we get? And in fact, Mr. Pepper correctly points out that Metro approved up to 130. However, at a mix of 70% one bedroom, 30% two bedroom, which is 2E, and the parking required by LVH, that's not actually a Metro zoning requirement, but that is contractual here. And so we could not get to that number of 130 units on the property. We ended up underneath 125, which brings us up to that floor price. And we believe as well that, that this situation for those same reasons is distinguishable from 4/8 and that line of cases. In 4/8, the parties agreed to that fair market value, which must be determined by the parties negotiating in good faith. Here, again, we have a very clear price formula. There was simply nothing that the parties could agree upon in the future at this point that relates to the option price. And in fact, Freeman's argument here would invalidate essentially the entirety of Section 2, the option price provision, including that entire formula. That would render that meaningless. So it's clear at this point that the parties entered into this option agreement. They also agreed to extend the option agreement with an amendment that again extended that period during which our client was continuing to rezone the property to determine how many units could be developed and do the rest of that due diligence there. And what we see from Ms. Freeman at this time, she testifies that during that period, she sees down the street from her property that Core Development, which is a related entity of LVH, puts up a piece of property, I believe, around 5 acres for around $8 million. And seeing that, she testifies that that's where she calculates her price of 9.975. So during the option period, Freeman essentially decides that they would like to get more for the property than what they bargained for in the option agreement. And therefore, when LVH exercises its option at the price of $2.5 million for the option agreement, Freeman, rather than conveying the property, offers what they pose as a counteroffer of $9.975 million, which is a 300% increase in the option price. And the trial court properly found that this constituted a breach on the part of Freeman of the option agreement by failing to convey the property. And of course, that occurred on summary judgment, and the parties proceeded to trial where the issue reserved was for damages. And upon the parties arriving at trial, Freeman does at that time concede that specific performance is the proper remedy here. And at trial, LVH presents a great amount of evidence of the uniqueness of the property and the value to them, and how it could be of value to the greater Nashville community and provide that green space. And all of that is in the record there at trial.
Excuse me, Ms. Elliott, did you say Freeman agrees that specific performance is a proper remedy?
Correct. Actually in their pretrial brief, Freeman concedes that specific performance is the proper remedy here, and that was reiterated by counsel at trial.
But didn't they also say that the entity doesn't own all of the property, but 3 Freeman siblings do, and they can't perform?
Correct. So at trial, Freeman, again, concedes specific performance to be the proper remedy by way of raising for the first time this impossibility defense. So here, when we arrive at trial, Freeman says we don't own all the property, we can't convey it, there's an impossibility to specific performance here.
What in the record shows that they do not own all the property?
Well, Your Honor, that's really one of our big sticking points here. is I believe they introduced a draft title commitment in the record, which would have required a conveyance to Freeman LLC to ensure that they own all of the property. But what we believe is what is in the record preponderates against this impossibility defense. What is not in the record is a deed, and actually the trial court kind of pointed out the conspicuous absence of this deed. I don't have a deed before me, or other instrument, which goes to show, hey, there's missing meets and bounds, or there's an issue here, or identifying the area that is owned by the LLC as opposed to the individual members of the LLC at the time of the option agreement.
Isn't there's some sort of recorded filing in about 2000 that says the tract that the option covers is owned entirely by Freeman, and the property that the three siblings own is across the road?
That's correct, Your Honor. And that was introduced at trial, I believe, Exhibit 23 to the trial. And this was around, I believe the instrument was made in 2000 and recorded in 2001. And it includes a survey of the property. It's tracts 3 and 4, and it's the same property that is the subject to this option agreement. And also an affidavit accompanying that survey, where Freeman Investment, through Ms. Freeman as the manager of Freeman LLC, holds out to the world affirmatively that the LLC owns all of tracts 3 and 4. And when questions as to why go through those steps, why did you record this affidavit, Ms. Freeman notes that around that time, a surveyor had informed her that the title history of this property is complicated. So you would do well to record an affidavit on its face saying Freeman Investment LLC owns the entirety of this property here. There is some property owned by the individuals. It is tracts 1 and 2. That is a separate property. And again, that was executed and recorded on its face, holding out to the world that Freeman Investment LLC owns the property here. And we believe that for these reasons, in part, Freeman does not prove the defense of impossibility. They would need to prove.
In fact, that filing would say they could file, sign a deed over, this afternoon.
We agree. And if there is a portion of the property within there that the 3 siblings may have owned at some point, or again, it was not proven at trial. We don't know where it is. Ms. Freeman said she couldn't identify it. And it seems from the face of this affidavit that it seeks to create ownership by adverse possession on the part of the LLC. And again, that clock starts running at the latest point of this, this recorded instrument over 20 years ago now.
But again, there are no deeds to these siblings related to the property that is the subject of this option.
That's correct, Your Honor. There's no deeds in the record here. And so with Freeman having to prove this defense of impossibility, that generally includes these 3 points, and we've covered most of this here. First, that the performance is impossible or very impracticable. We don't believe that's proven for the reasons that we've just discussed. We don't think the record supports this at all in this case. And in fact, we believe it demonstrates the opposite. Second, Freeman should show that the event causing the impossibility was not reasonably foreseeable to them at the time when the option contract was made. We don't have that here either, because we see affirmatively that Ms. Freeman took steps to clarify title and any mistake that may be included in the title upon the surveyor telling her that there may be an issue here. And because that was over 20 years ago, we believe Freeman Investment LLC has held out to the world that it owns this property, and that is the case by adverse possession or otherwise. And finally, Freeman would need to show that it did not cause or could not have prevented the impossibility. And we think these facts also preponderate away from holding with Freeman on this one. Clearly, anything that did occur was between the conveyance of the individual members of the LLC to the LLC. And so they can't really claim no knowledge of this or that they could not have prevented this impossibility. And Your Honors, in conclusion, we believe that the option price formula is clear. We believe it was assented to by the parties. The price can be ascertained based upon the plain language of this option agreement. 4/8 also stands for the conclusion that if we can ascertain the price, the contract should be upheld as enforceable. We don't believe Freeman proves impossibility here to convey the property. We believe they can convey it. We believe they own it. There simply is insufficient evidence in the record to support the impossibility defense. Freeman may have changed its mind about the price that it wanted, but that is simply not a sufficient reason to avoid their obligations under the option agreement. And for these reasons, Your Honor, we respectfully request that this court affirm the decision of the trial court.
Thank you, Ms. Elliott. We'll now hear rebuttal from Mr. Pepper. Mr. Pepper, I can't hear you.
Yes, I needed to can you hear me now? Okay.
Yeah,
What
yes, sir.
was conceded at the trial court level was it for a matter of efficiency as between the court had already ruled against us. We had lost the case. The court was going to decide, is it going to be compensatory damages or will it be specific performance? We simply conceded that as between those remedies, specific performance is the appropriate remedy because about every case in Tennessee says where you have a contract for the sale of land, every piece of land is unique. Therefore, specific performance is the appropriate remedy. There is evidence in the record that the Freeman siblings, there is a deed that was filed with LVH's pretrial brief, in fact, that is the deed by which the Freeman siblings inherited their interest. It was a deed from Fount Williams. But what the trial court record establishes is that LVH's own lawyers, after doing a title search, directly advised LVH, unequivocally, the Freeman siblings own part of this property. The Freeman siblings own part of this property. Mr. Campbell admitted at trial that he knew the Freeman siblings owned part of this property. That is undisputed. There were no facts put into the record to disprove that the Freeman siblings own part of this property. And in fact, LVH admitted it. So the fact that we don't know exactly where it is doesn't matter. The trial court's order, essentially, it would require, if a deed is executed, it would require Freeman to convey land it doesn't own, something which no court in the nation we can find has ever countenanced. And it would cloud the title of three individuals who are not before the court, and who are not parties to this contract.
Why did Freeman provide an option to sell property it doesn't own?
That's a very good question, and the answer to that is
thank you. I specialize in that.
They did not know at the time the option agreement, and this is a critical equitable fact, that was at the time the option agreement was executed, Freeman didn't know that these three individuals own part of the property. In fact, LVH did not find it in its first title search. It took it 2 title searches because it was a very complicated piece of property. So at the time that Freeman executed, the parties entered into the option agreement, Freeman had no idea. Very importantly, from an equitable standpoint, at the time LVH executed the option, it had been advised by its lawyers unequivocally, the Freeman siblings own part of this property. Here's what you ought to consider doing, having them join the contract. Instead of doing that, LVH brought suit and has sought successfully so far to have the Chancery Court of Davidson County have it transfer property of individuals that are not before the court.
What is the effect of the 2001 filing of Ms. Freeman's affidavit about who owned which parts of that property?
Well, that was a mistake. It was based on what a surveyor told her. The record establishes it was an honest mistake. And the problem with that is if I go file a deed on a piece of property in Davidson County today and state that I own it, I can file it with the Register of Deeds, but I cannot affect, even if I'm mistaken, I cannot affect the property interest of individuals who don't join in that conveyance or that filing, but who own part of that property. The other thing that the trial court did was whether specific performance should be applied should not be limited to have we proven impossibility. And by the way, I was not speaking of impossibility as the affirmative defense that you use to defend against liability on a contract. I was simply telling the trial court it's impossible for us to convey property we do not own. And that the trial court should have considered all of the equities of the case. LVH in this case is not free from blame. And a critical equitable fact is Freeman did not know at the time it entered into this option agreement that the siblings still own some of this property. The other critical equitable fact is if the trial court's order is upheld, what will happen is that the titles of 3 individuals who are not before the court, who are not parties to this agreement, will absolutely be clouded. And
can we identify what parts of the property these 3 individuals own?
I believe that would be possible. It is not in the record at this point. Thank you, Your Honors.
Thank you, Mr. Pepper and Ms. Elliott, for your arguments. We will take your matter under advisement. Ms. Lindsay.
This Honorable Court of Appeals is now in recess.
Thank you, counsel. You may be excused.
Thank you, Your Honors.